Any mention?
I may crave your lordship's indulgence, my lords, for moving an unlisted matter. Offshoot of the matters that have been decided by my lords, my lords. Not related to that issue. Issue is, my lords, the electricity matters, my lords. Issue is, my lords, that while your lordships have disposed of the matter, my lords, yesterday the electricity lines of all these petitioner companies have been disconnected without adherence to section 56. Only limited issue. Highly obliged.
Please, Lordship, I beg to mention item 34. I pray for 2 weeks' time, Lordship.
Why?
Lordship, the conducting counsel has a personal difficulty.
No objection, Your Lordship. No objection, no objection, Your Lordship.
What's the matter about?
It's a service matter, Your Lordship. I'm praying for promotion.
Promotion?
Yes, Your Lordship.
Much obliged, Lordship. Please, Your Lordship, I beg to mention item number 22.
Number?
22. I prayed for 2 weeks' time, Your Lordship.
Can't hear you. 22?
22.
Yes. Why don't you take time? Is
That dismissal case from Meghalaya Rural Bank, Your Lordship. In fact, we have heard in part, Your Lordship, there were some citations to be provided.
He has, the council has some personal difficulty.
You can't have them reach half-heard like this. There's a part that matter. You can't ignore part that matters actually. What to do? You object.
You have to come after a week, Your Lordship. If he has a personal difficulty, but then...
Mentioned to me on behalf of the young counsel in a personal difficulty. Shall we just matter for 1 week?
Obliged. Yes, Your Lordship.
Yes.
Please, Your Lordship, I beg to make a mention of item number 21.
Number?
21, Your Lordship.
21, which is a part of matter.
Conducting counsel is out of session, Your Lordship. I pray for short accommodation, Your Lordship. Short accommodation. I'll be back by tomorrow.
The same order.
Highly obliged, Your Lordship.
Two matters? Yes.
Please, Your Lordship, I beg to mention item number 4 from the supplementary list, Your Lordship.
We have expressed some urgency in this matter.
Why don't you do the other matters part of that?
Mr. Day is doing that one. That matter, Mr. Sir is doing it. Here there is some urgency, His Lordship's recollects regarding the grant of study leave, Lordship.
One thing you do is that they have filed an application.
Lordship, yes.
Doing that.
Similarly,
in a similar situation, this PSF serviceman was allowed to go study leave.
Lordship.
Have you got instructions on that?
No, Your Lordship.
Let it be taken up next week because there is some urgency, Lordship, from September onwards.
For adjournment, as they're still meeting instructions on the additional affidavit filed by the petitioner, wherein which year wherein in a similar matter.
In a similar matter, Lordship, permission was granted to pursue diploma in electrical engineering.
The PSF servicemen to avail of study leave
For diploma course.
to pursue diploma in
As electrical engineering.
This is Monday,
Not sure.
this matter on Monday. This matter stopped expected next year. Instructions have been received.
Highly obliged, Lordship.
Otherwise, admissions will close.
That is the only difficulty.
Yes.
Obliged.
My lord, I beg to mention item number 33, my lord. This matter came up last week. On my prayer, Lordship is allowed to fix it after a week, my lord. Mr. Sen has to go for some medical emergency again, my lord.
His own medical emergency is someone else?
No, my lord, his missus, my lord.
Okay.
Okay, Lordship.
After 1 week?
My lord.
May I please, Your Lordship, I beg to mention number 23, Your Lordship. May this matter be fixed after 2 weeks, Your...
Who's arguing counsel?
R.S. Malyang. He's having some personal difficulties here.
24 is the connected matter, Lordship. 24, Lordship.
What's the matter about?
Service
Service benefits, Lordship.
No, wait, there was one.
Muda.
Lordship.
24, Lordship.
We have no objection.
Objections.
Yes. After 1 week.
2 weeks, Your Lordship, please.
Okay, 2 weeks.
Much obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 29. I pray for 3 weeks, Your Lordship.
3 weeks, why?
Your Lordship, the conducting counsel has some personal difficulties. That's why.
Lordship,
Regarding that,
the MSc appeal or judgment which was passed. Yes. That same matter. In fact, my lord, I was humbly submitting that both sides have already finished their submissions. At least from our side.
satisfied your submission.
Very well. We'll try and satisfy.
We want some more concessions from you. You're an insurance company.
My lord.
So what makes you say that you finish your submission?
Lordship had heard the matter, but we'll let it come up again.
Mr. Jindal or Mr. Wanda is not there. Okay. 3 weeks. Yeah.
Much obliged, Your Lordship.
Your Lordship, I beg to mention item number 30. I've informed the other side, Lordship.
I said be happy, yes.
Highly obliged, Lordship.
Supplementary list, item number 1.
Lordship, I'm praying if this matter can be taken at the end of the board, Lordship. Then senior Mr. Paul is leading, Lordship. Lordship, here what has happened is, Lordship, there was expression of instrument floated by the Fisheries Department, Lordship, for presentation of instrument, Lordship. EOI,
Lordship, if I may, basically it was an EOI for a DPR regarding the Fisheries Department. And Lordship, I would submit at the threshold that this is purely a civil matter. They are claiming recoveries of dues under contract.
These are admitted dues, Lordship.
Dues under contract.
Lordship, there has been several representations, Lordship, filed after completion of the DPR. We have submitted the DPR, Lordship. Lordship.
The work order pursuant to the EOI was 18th of July 2022.
But no order was issued
in my favor, Lordship.
In their name, there's no difficulty with that.
Lordship, after that, Lordship, we have completed the work. We have submitted DPR. Then there was
acknowledged by them.
Lordship.
They have accepted the DPR.
Lordship.
Yes, Lordship.
They have accepted, Lordship. Thereafter, what has happened is, Lordship, there was some observation made by the Government of India with regards to the restructuring of the DPR, Lordship. Thereafter, Lordship, I have written several representations for clearing my dues and giving us the letter for restructuring the DPR, to which, Lordship, till date they have not replied, Lordship. Lordship, let them come with... no, Lordship, no, Lordship.
Lordship, if I may, at the threshold, this is a purely civil matter. It doesn't warrant the writ courts. Please, Lordship.
You are accepting notice on behalf of...
Please, Lordship.
List the matter after
2 weeks, Lordship. Lordship.
Grateful, Lordship.
You come prepared.
Lordship.
Item number 2.
Please, Lordship. So this matter emanates from an order passed by the Lokayukta, which is in Lordship. In our humble submission, it is beyond jurisdiction, and it is also against the principles of judicial consistency. The subject matter, there was no jurisdiction of the Lokayukta over the subject matter concerned, and over and above, Lordship, this matter is already decided by the Lokayukta itself in a previous matter. In a similarly, Lordship may kindly have the. Lordship may have. In fact, this was placed also at the time of argument of the matter. Lordship may kindly see this order. This is an order, Lordship, passed by the chairperson of Lokayukta on 19th May 2022 in complaint case 3 of 21. If Lordship is pleased to see the last paragraph. The chairman and the secretary of the VEC are elected members of the job card holders to run the affairs of the VEC for execution of the MG and REGS in the concerned village without payment or income. Their names do not find place under Section 14 of the Lokayukta Act or under Clause C of Section 2 of PC Act. So a categorical finding was given, Lordship, by the chairperson. Now kindly see, Lordship.
VEC means this is not the VEC matter?
VEC matter only. Kindly see page 51, annexure 3 of my writ petition, Lordship.
Yes.
And before that, Lordship, may kindly have the complaint itself, page 24.
Okay, this is 51 on the
51, Lordship. It does not say anything, just says, heard Mr. So-and-so, for the complainants present, Mr. So-and-so, learned constable 2, 3 and 4.
Mr. Sikori, you are placed there also?
My lord, I heard the parties, prima facie
You are for the
DC and others.
Yes.
BDO, DC and...
Then how you are appearing for them here also?
My lord, because they are the same people.
He is also for the respondent.
I am appearing for the respondent, my lord. Deputy commissioners and block BDOs, they were made parties there.
Okay. Yes.
So, Lordship, by this order of 15th of... Yes, and they have proceeded for under Section 20, bracket 5 of Lokayukta Act to submit a report by the DGP. Despite, Lordship, that in fact this order is not even a speaking order. All these objections which were raised, certain objections were also raised by the state respondents on maintainability itself. Nothing has been recorded, Lordship, firstly.
Is that correct?
Yes, my lord.
My lord, may kindly have a look at the act.
They are not public officers.
They are not public officers, my lord. Yes.
And once there is already
public,
what happens is, Lordship, by
public servant, my lord.
The VEC chairman is basically the headman of the village. By virtue of his headmanship, he becomes the ex-officio chairman. No corruption. An allegation is not even also of corruption, Lordship. There is no finding in the report on merit also. There is nothing.
Well, may kindly come to page number 4.
And the complainant was an accomplice to the alleged misappropriation, if any.
Complainant also is an accomplice.
If any.
Why are you saying that?
Lordship, if that is come in the report, that he himself during his term,
4, my lord.
Complainant was the previous headman.
It defines public servant. It says public servant means a person referred to in clause A to H of subsection.
Section 14.
My lord, this is page number 4, that is section 2.
Public servant.
Yes. It says, my lord, public servant means a person referred to in clause A to H of subsection 1 of section 14. Now, my lord, may kindly see section 14, page number 11. Chapter 6, my lord, jurisdictions of Lokayukta to include chief minister, ministers and members of legislature and officers of employees of the state government. Now here, my lord, all the definition from A to H, my lord, it does not include the VC chairperson and moreover there was a bar.
See, what about G?
Also, G talks about...
And it's a director, manager, secretary or other officers of every other society or association.
See, any person who is or has been a director, manager, secretary or other officer of every other society or a person or trust.
Yes.
By whatever name, wholly or partly financed with either the state government and another scheme, anything is there.
No, not sure.
That appointed.
It will not cover under this, my lord.
And moreover, there is no notification also.
One bar, no?
Specify.
That they pointed out from here.
Explanation of purpose of clauses G and H is further clarifies that any institution by whatever name or corporate society, trust, association of persons, partnership, sole proprietorship, limited liability partnership shall be entities covered with clauses. So,
Lordship, no, section 14 in my humble submission, Lordship, would not apply for
the
Lordship, yes. No, clause H, if Lordship is pleased to see, that is with regard to societies and associations which receive donations under the Foreign Contribution Act.
Yes.
So that is not applicable, Lordship.
G and H.
Yes, H and G, Lordship.
G and H.
G and H.
Yes.
No, only H and G, Lordship. G says any person who has been a director, manager, secretary, or other officer of every other society or association of persons or trust, whether registered under any law for the time being enforced or not, by whatever name called, wholly or partly financed and aided by the state government, and the annual income which exceeds such amount as the state government may by notification specify. So this is not attractive, Lordship, in my humble submission.
Your association of persons, the VEC form under
Lordship,
and so you're holding the position of president.
Chairman of the...
Chairman rather, okay. Chairman. And so you're a public servant because if you're overlooking, supervising the schemes done in the villages.
Lordship, in my humble submission, section G, Lordship, is because...
not financed by the state, no.
Because the scheme, funds come from the center, that is one thing. VEC is just the implementing agency, so to say, under the...
VEC is the most important cog in the whole wheel.
No, I understand that. I have no dispute with that. My only submission is in clause G, they are not covered, Lordship. That was never the argument also, in fact.
See, whether they get registered in any law, every other society, association, person or trust, by whatever name called, solely or partly financed aided the state government.
For that, it has to be a trust, association, and society, my lord. No. Maybe name may be different, my lord.
It says that fine, but then it's under any law or by whatever name called.
Yes, the name may be different of the trust. That is what it means, my lord. Yes, my lord.
And especially considering that the matter was, already a final order was there.
If this order is wrong, the order, then the court.
That may be, but the Lokayukta, in my humble submission, Lokayukta by itself could not have. This amounts to a review, Lordship.
They are at the grassroots level, whereby the funds flow directly to them, where they distribute the money for the mandates. And if there's corruption allegations against at that level, and if there's no recourse for them,
no, in fact, what was this recommendation of the report was also for FIR.
There in the file.
Okay, to notice the deliverable in the course of with the MSN Fund President on behalf of 1, 11, 12, and 20. For the step that is responded. This separated that challenge in the prerogative petition is directed against the June order dated 9th of dated
15/7.
Where the 15/7
2025,
whereby the respondent for one, that is the person Meghalaya Lokayukta Shillong has directed for investigation.
Under section,
correct?
No, investigation under section 20 bracket
5. Under section 20 bracket 5 of the Meghalaya Lokayukta Act 2014 and for submission of vote within 6 months. 15/126. And the submits that the one Lokayukta has to jurisdiction in as much as the persons the petitioner to complain against do not come within the definition of public servant as given section 14 of the Act. Further, Mr. S. has produced an order of the Archival Data 19/5/2022, wherein it has been held that the chairman and secretary of the VEC, the elected members, the job card holders, and do not come within the purview of section 14 of the Lokayukta Act or under clause 1 section 2 clause C of the Corruption Act. So he therefore submits that as the petitioners are the chairman and other members of the
chairman and secretary
of the VEC of what?
Nongrim Nongladao village.
Of Nongladao village, Where is it?
This is in Riboi district, Lordship.
Riboi district. The consideration and litigation of for indicating matter is legal. Mr. Henderson appears for the former respondents. Also supports a submission made by the for the petition. Having heard and counsel for the parties, though the earlier order exists, the earlier order is 95/2022, passed by the earlier
If I may make a small submission, Lordship, perhaps under clause G they will not be covered because there is no income.
And
income is not there.
One point, my lord, I want to raise. There is a bar, specific bar under the Act only, section 14. It says, provided that no action under this section shall be taken in case of a person serving in connection with the affairs of the union. The first respondent here, my lord, personal respondent is IS. So he is in the service of the union, my lord. My lord.
Is the existence of for the matter required for the examination. Accordingly, this received after service.
Nationality steps and all that.
2 weeks once.
And further, the process is made out for if asked any.
I filed a miss case, Lordship.
You have to be in case the further proceedings in Tulsa.
Complaint case 7 of 24. Complaint case number 7 of 2024.
Case number 7 of 2024. Not about chairperson. For the chairperson as well shall remain state and for the others.
Much obliged.
Obliged.
Daily list item number 1.
May it please, Lordship. Also, I'm appearing in item number 1, 3 and 4, Lordship. These are connected matters, all arising out of the same advertisement, Lordship. Item number 1, we're challenging the DLED certificates, the 18 months DLED certificates, Lordship. And no, Lordship, here we need some time to ascertain, as in like, because according to Supreme Court judgment, Lordship, it says that
18 months valid.
18 months, candidates who have obtained 18 months prior to 31st March 2019. After 31st March 2019, those who have obtained 18 months, they are not valid, Lordship. Yes, Lordship.
No, my lord.
No, according to
that is the condition for availing 18 months DLED, Lordship. Only those who were in employment prior to 2017, that is the condition they can avail the opportunity to obtain the degree for 18 months, Lordship. They were all the teachers who were appointed, Lordship. They were employed prior to 2017, Lordship. Yes, Lordship.
No, Lordship. According to the latest judgment, Lordship, we have perused. Lordship, the recent judgment by the Supreme Court, Lordship, we have perused, and we found out that candidates who have obtained prior to 31st March 2019. Yes, after 31st March, they are eligible, Lordship. And after
2019 or prior?
Prior, Lordship. They are
eligible.
They are eligible, Lordship. After
they are eligible prior.
Yes, Lordship. And after
2019,
they are not eligible. We want to ascertain how many among the private respondents there, Lordship.
They are solely relying on Jasbir Singh's judgment, Lordship. That there was a confusion, that is why subsequently it was clarified. And there is a latest judgment in April, Lordship, this year, Lordship. That was more clarified, Lordship.
Yes, Lord.
They have
and that judgment has clarified, Lordship.
Yes.
In the review petition,
No, even after that also in April, that the matter from Calcutta High Court reached to the Supreme Court, that judgment has clarified. Even unaided teachers also, those who are working in unaided school also, that will also covered.
I need two weeks time accommodation, Lordship. I want to ask.
Unnecessary this matter is dragging, Lordship.
Lordship, we have some difficulty, Lordship, today. 2 weeks, Lordship. No, Lordship, we need to seek instructions from the clients also. Lordship. So,
Honestly, it's been
Because item 1 and 3 were challenging the DL at 18 months. Same. All arising out of the same advertisement. Lordship. Same advertisement. And in item number 4, Lordship, the government of Assam has to appear, Lordship, because they are challenging the fake certificates which they have obtained from unrecognized institutes, Lordship.
So we understand the core issues regarding the, what we call the validity of those
18 months.
18 months.
So, Lordship, as far as that aspect is
now,
concerned.
the court decided that fine, you don't need 2 years, 18 months will suffice. So,
but candidates who have obtained after 30.
My lord,
This is
that way it's after post and pre, pre and post 2019.
They have. Do you have that?
Let the court try to understand also what is your objection.
But this 25 judgment also says the same thing. That 18 months is for the in-service teachers, my lord. 18 months in-service teacher. Even now it has come to the Supreme Court. But they were not in-service teachers who are being challenged now. Those who have declared past.
To say that those under challenge now they want us in-service teachers.
They are not.
Otherwise, they will not get the 18-month DL, Lordship.
They are not, my lord. That is the grievance here.
Otherwise, that is one of the preconditions that he should be employed on or before 2007.
Got a list, my lord, which shows that only few of them are in service and the others are not. 17 of them are not in service, my lord.
28 of them.
17 out of 34.
Year 17. So far as other repetition, they are challenging the subsequent list, Lordship.
Do you have the list with you? They got to fight.
The submission.
My lord, that SCC reported. Yes,
that is the recent judgment.
We are relying that judgment.
Kaushik Das, no?
Yes, we are relying that judgment. My lord will kindly see paragraph 36. This is the SCC reported. I'll just, if my lord, read from paragraph 36, Lordship.
Only his handicap was senior, not here. That's the thing.
Not some other day.
Okay.
6, huh?
It is not necessary they have to be employed in any government school, Lordship. Even unaided private school. That window is given only to those teachers, Lordship.
Who were in service prior to 2017.
Yes. See, the thing that, but he's saying that you're not in service. Is that correct?
No, my lord.
Cannot be.
Then on what basis submission?
We have already enclosed a list in the writ petition where it is shown that 34 have been declared pass. Out of them, 17 are in service and others are not. That is the grievance we have got.
As the judgment says, to prior to window was in service teacher, the notification.
Prior to 2017.
Yes.
Those who were appointed prior to 2017 and got this within 2019. After that, it is not applicable to anyone. This judgment also says another judgment also says.
1 week, Mr.
2 weeks, Lordship. We have some difficulty, Lordship, 1 week, because...
Why all the clients are...
No, Lordship, because...
No flood.
2 weeks, Lordship. We need 2 weeks time.
No flood, my lord.
No flood.
No flood in Garo.
There's an excuse given. Every time we ask affidavit also saying even the officers are stuck when it's flood.
No, this time in Garo is no flood.
This is item number 1 and 2, Lordship. This is
not stuck by flood. Then we dispose it off.
1, 2, 3.
1
to 4. 2 weeks time.
But then next day no further.
2 weeks time.
The killers are appearing in items number 1, 3 and 4 of today's petition raise that time to take specific instructions with regard to the instructions of the details of the teacher officers whose appointments have been challenged. The same objections by the constable appeal on cases on the ground that after the judgment of the Supreme Court, wherein 18 months diploma has been considered valid, nothing remains for further consideration in these matters. Added to the fact that the audit was teachers. However, at the end of justice and with the absence of the senior counsel, this audit is expected next day. Further adjournment will take it.
Deeply obliged. Hello.
Item number 5.
Your Lordship.
Where are you going to file affidavit? Fine.
Oh, yeah.
Why?
Your Lordship, due to some personal difficulties, the counsel for the respondent, she is unable to appear.
How many times you prayed for time?
Only this time, Your Lordship. And we are still researching in this.
How many opportunities have been given to file affidavit?
Your Lordship.
Plenty.
Yes, Your Lordship.
How many times? Just for how many times have fought for the time?
This is the second time, Your Lordship.
Second time?
Yes, Your Lordship.
Okay. Second time, you sure?
Yes, Your Lordship. Your Lordship, the interim order may continue.
Interim order can continue.
Item number 6.
The applicant in Order 711 application has to reply. Has to reply it, Your Lordship.
Who's been for the side? Where is the Pandit? Your reply is today?
Yes, sir.
Yes.
So, just a brief recap of what had mattered in this, what had transpired in this matter was that, my lords, as far as my 711 application is concerned, there were two objections, primary two objections, one on section 81.1 and the other one on section 81.3.
The two objectives that he said they sign all pages, correct?
Right.
And number 2 is that you didn't seek leave of the court to file the 711 application.
Right. These are the two objections that have been taken to my application. So, my lords, as far as the objection regarding filing of the application is concerned, the reliance has been placed upon Rule 10 of the Guwahati High Court rules. If your Lordship has page 148 of my application, your Lordship will find the Guwahati High Court rules. Rule 10, my lords, may be in your Lordship's copy at page 151. All interlocutory petitions should bear a court fee stamp of ₹10 thereon and may be filed before the judge with permission of his Lordship.
Yes.
Now, my lords, this application, once it was filed, my lords, I don't really believe that, my lords, this is a bar as far as filing of an application is concerned under section 81 of the Representation of People's Act. Yes. That is not objected to. The only aspect which is objected to is whether it has been filed with the permission of the court or not. Now, the rules as such are in addition to section 81(3). If your lordship takes section 81 and section 86, there is no requirement of any permission being sought before filing an application under section 86. The rule does not say that you require a prior permission. As soon as my application is filed, notice is issued, thereafter replies is filed, rejoinder is filed, arguments are made, there is a deemed permission on my application. There is no requirement for me to take a prior permission from this court before filing an interlocutory application. I file an application, thereafter your lordships takes cognizance of that matter, notice is issued. That is good enough for satisfying Rule 10 of the Guwahati High Court rules. So, my lords, I believe that is the Rule 10. I don't think so, my lords, creates any bar as far as the maintainability of this application is concerned.
Yes. But how do you get around it? I don't think that your argument will suffice.
Because, my lords, kindly sees then 81 and 86, because which are the statutory requirements. And this, my lords, objection has also been taken in other election petitions. Which, yes. So I do not believe that this objection, although has been taken, but will not stand. If your lordship sees.
Okay, reply to other objections that I made.
Yes, yes, my lords.
Okay, we'll give that a go by.
Yes.
Okay.
Yes, my lords. Now, the essential objection which has been taken in respect of the election petition is that a certain number of judgments have been placed saying that there is a theory of substantial compliance.
Yes.
So if you
answer that is
yes.
What is substance over form?
Right. So there is a theory of substantial compliance, and section 81(3) to an extent will stand diluted if the election petitioner substantially complies with the requirement.
Yes.
That is the position of law which has been canvassed by way of certain judgments. Now, my lords, in this regard, the first judgment which was placed before your lordship was the judgment of 1964 by the name, my lords, Murarka Radhe Shyam Ram Kumar, and reliance was placed on para 11 of that judgment. Radhe Shyam. This is 1963 SCC Online 129. There must be a compilation, your lordship. There must be a compilation which the learned. Yes.
This is right. Petitioner.
Yes, my lords. And attention, my lords, was drawn to para 11.
Yes.
Now, my lords, in this, if I may also place reliance upon certain portion of this judgment. So, para 11 says, my lords, we agree with the High Court and the Election Tribunal that the first defect is not a defect at all when every page of the copy served on the appellant was attested to be a true copy. Under the signature of the petitioner, a fresh signature below the word petitioner was not necessary. Subsection 3 of 81 requires that a copy shall be attested by the petitioner under his own signature, and this was done. As to the second defect, the question really turns on the true scope and effect of the word copy occurring in subsection 3 of section 81 being mandatory in nature, all the requirements of subsection must be strictly complied with, and the word copy must be taken to be absolutely exact transcript of the original. On behalf of the respondents, the contention is that the copy means that which comes so near to the original as to give every person seeing it idea created by the original. Alternatively, the argument is that the last part of subsection 3 dealing with a copy is merely directive, and for this reliance is placed on decision of this court in Kamraj Nader versus Kunju Thevar. We are of the view, now this is very important, Lords, we are of the view the word copy in subsection 3 of section 81 does not mean absolutely exact copy, but means that the copy shall be so true that nobody can by any possibility misunderstand it. In this view of the matter, it is unnecessary to go into further questions. So the standard which has to be applied, and I am not quarreling with that standard, that you cannot lead to a situation where the copy which you serve upon me contains certain vital defects, contains defects which
what
can...
do you mean, does not mean and have to be exact copy, but means that a copy shall be so true that means that even some exact copy,
right,
and if there are discernible variations or differences,
right,
can be taken a true copy even though the purport or the import of the entire document comes through. What does it mean? Now, what will be a meaning of exact copy or true copy then?
So, Milords, what we are looking today...
Copy is always an exact copy.
Yes, a true copy has to be an exact copy, and what we are looking to today, this judgment is of 1963. In 1963, so because without the benefit of the modern technology, when the yes, of photocopying, so when you are copying, there may be certain comma or full stop missed. That is all right. That is not creating any difference. But almost, it has to be almost identical to the election petition. And if it leads to certain defects which are of such a nature, which can put me at a disadvantage in mounting my defense, then that has to be considered to be a deviation from the copy which has been served. This doctrine, to my understanding, has been put forth just to ensure that there is some amount of practicality in supplying a copy, keeping in the consideration the times in which the judgment was passed in 1963. So and thereafter, my lords, the judgment again on the subsequent page.
This is what the court can understand till now. Doesn't mean after the copy, but it means the very copy which shall be so true that nobody can by any possibility misunderstand.
Right.
What does the Stokes judicially say on this aspect?
Right. So
have you extracted black or?
I have judgments which have quoted the dictionary definitions. I will place those judgments. I have also a certain number of judgments where the Supreme Court has held that these copies which have been served are not true copies. So that is the position. But also again on the subsequent page, this aspect has been reiterated. Yes, my lords. In the subsequent page, my lords, I am just reading about 10 lines above para 12.
Okay. Applying the test.
It means.
Okay.
It means a copy so true that nobody can by any possibility misunderstand it.
What you said, you misunderstood it. So it is on honest of whom? is on the respondent. I can't understand it. So when we take it, they say that you can't possibly misunderstand it. So whose word is to be taken?
So I will place Melody in the facts of my case. In the flat.
How it can be a true copy? You have to argue on those lines.
Yes.
And how this definition will not. I mean, this whatever.
Yes, I will demonstrate.
Your case that the copy served on you is not a true copy of the copy filed for the registry.
Right. I will demonstrate that. I will demonstrate that the copy which has been served upon me,
it's not the same. It's not the true.
A reasonable person will not take it to be the same copy.
Yes.
I will satisfy that standard. So, my lords, that is the standard which has been, because this is something which has been laid down as a matter of interpretation of section 81(3). So, I am not quarreling with the interpretation of section 81(3) as far as the judgment is concerned. Similarly, all the remaining judgments which has been cited are after 1963 and state the same thing. So I need not go into T.M. Jacob and Anil Deshmukh and so on and so forth. In fact, in one of the judgments which has been placed reliance upon, item number 3, 1992, 2 SCC 205, the defects were in fact cured before the hearing. So Anil Deshmukh, the defects, and this judgment has been placed reliance upon your lordship in one of the election petitions, election petition number 2 of 2023, where the defects were cured. So that is the situation, my lords. Now, coming back, my lords, to the fact situation that we have in our case. In our case, my lords, it's a kind of a it is a peculiar fact situation, because if your lordship just takes, there are two significant differences in our case. One is that an election petition has been filed. Election petition has been filed with notarization. The stamp and seal appears on the first 3 pages of the election petition, and thereafter appears on the last 2 pages of the election petition. The stamp and seal is absent in the middle pages of the election petition, and the stamp and seal is also absent in the annexures. The copy which has been served upon me is bearing a stamp and seal of a different notary. It also does not, all the signatures which are there are not stamp and seal, only the first 3 pages and the last 2 pages. The annexures are not notarized. Now, in these facts and circumstances, your lordship has to decide whether the copy which has been served upon me is the same copy or not. Now, before your lordship goes to the relevant pages, just for refreshing your lordship's memory, I will place, my lords, the Guwahati High Court rules. The Guwahati High Court rules as far as filing of the election petition is concerned. If your lordship takes 147 of the application that I have filed, yes, 148. So, my lords, in this rule 1A, every such petition shall be accompanied by A, as many copies thereof as there are respondents mentioned in the petition, together with 1 extra copy, all copies being fully attested by the petitioner under his own signature to be a true copy of the petition, and as many envelopes as there are respondents bearing requisite postage stamp to enable service to be effected by the registered post with acknowledgement due. So I place emphasis on the fact that all copies being fully attested. Now, let's just for your lordship reference, I may take your lordship to page of the same application, page. My lords, this is an application which I have attached both the copies which are there. Your lordship will find the copy which has been served upon me at page 21. Page 21, my lords, bears the notice, and thereafter your lordship can see from page 29 onwards. The stamp of the notary, my lords, of Mr. J.F. Blah, and there is a instrument number mentioned. First, second and third page notarized, and thereafter, my lords, the notarization is absent. Yes, my lords. And then it is absent. Finally, resurfaces, the notarization resurfaces at page 49 and 3 pages of that. So, fully attested, a copy which is fully attested under the signature of the election petitioner, 3 pages notarized in front of a notary. That means I can take a presumption that if a notary, a public officer who is also a person knowledgeable in law, notarizes and affirms that yes, this person came before me and signed it, and remaining pages not notarized, so it leads to a presumption that remaining pages are not signed by you. And thereafter, adding more confusion to this situation is the election petition which has been filed with this honorable court, which your lordship will find at page 86. '86 bears a notary stamp of a different notary. Here also 3 pages notarized, and thereafter nothing is there.
Initial 3 pages, the last 3 pages.
Yes. So whether an election petitioner can casually file an election petition, some pages wherever he finds it convenient, he signs it and gets it notarized and files it with the High Court.
So according to you, no substantial compliance.
There is no substantial compliance of section 81(3). So, my lords, in this regard, last time, my lords, I had placed one judgment of the Guwahati High Court. I will not, my lords, take your lordship to that. Just one more judgment on that point, and then I will place, my lords, certain judgments on section 81(3). One judgment on the presumption that arises out of notarization. Here in this case, the election petitioner chose to get the signatures verified by a notary. And when you get your signatures verified by a notary, only certain pages are verified and certain pages are not verified. It would not amount to compliance of section 81(3). It would lead to doubts to the fact that whether the remaining pages are signed by the election petitioner or not, and that too different notary. So, my lords, here I will just place that judgment. This is, my lords, 1991 SCC Online, Bombay 205. Para 10. Para 10 and 11 minutes I will please. Mr. Sonavane was enrolled as an advocate by the Bar Council of Maharashtra in the year 1964 and appointed as notary by the government of Maharashtra in 1986. Mr. Sonavane has stated in his evidence that he did not know either the plaintiff or the defendants. Mr. Sonavane was asked to explain the procedure which he followed when true copy of a document was required to be certified by him as a notary. Mr. Sonavane stated that he compares the copy produced before him with the original and then certifies the copy as true copy after such comparison after making reasonable verification. Mr. Sonavane has stated in his evidence that sometimes office copy of the document so certified is obtained from the party concerned and kept along with his record. But the practice followed by him is not uniform. Mr. Sonavane has admitted that he had not obtained in the instant case copy of the document in dispute while making the endorsement thereon as true copy or kept any record whatsoever with him in respect of his notarial act. Mr. Sonavane has admitted in his evidence that he cannot remember now as to who had come to his office for certification of the document in dispute. Mr. Sonavane was asked pointed questions in his cross-examination as to what precaution he had taken to satisfy himself as to whether the original was signed by the executant thereof. On this aspect, Mr. Sonavane stated during the course of the cross-examination as under, I do not verify the identity of the party who has signed on the original document. If someone else had signed on the original document in the name of some other party, I cannot say one way or the other as to what is correct position about the identity of the executant of the document. Mr. Sonavane also stated during the course of the cross-examination that before certifying the document as a true copy, he compared the copy tendered to him with the original and found out whether the original was signed by the advocate and the party concerned and whether the copy was identical with the original. Mr. Sonavane was also not in a position to throw any light on the question as to where was the original document or who in reality was the executant thereof. Now let's on the next page. It says the question in these matters can always crop up as to whether the proper person had executed the original document. The law takes judicial notice of seal of a notary. In ordinary course, an initial presumption may be made about the genuineness of the notarized copy of the document. The underlying idea behind such presumption is that the notary is normally a responsible member of the legal profession and he is expected to take due care to satisfy himself about the identity of the party appearing before him. If the party appearing before the notary is not known to the notary must get the party identified by an advocate known to him and take signature of both of them in token thereof. Notarized copies of power of attorney and other documents are filed with banks, courts and other public institutions. If documents are marked as true copy by the notary without taking due care and even making any entry in the notary register without taking signature of an advocate identifying the executant or without taking other reasonable precaution, it cannot be said that the notary is discharging the duty in accordance with law expected out of him. Good faith implies due care and caution. So, my lords, here the situation is, thereafter it goes on, that there is some amount of legal presumption that comes with the notarization process. And today the notarization process, as far as your lordship's copy is concerned, was undertaken by one Miss Lingba, and for me it was done by Mr. Blah.
No, it's done by Mr. Blah in the main election petition. No.
It's the opposite.
It's the other way around.
Other way.
Lordships have said it.
So now the situation is, my lords, section.
Yes.
The summary of the judgments of the Supreme Court on this aspect has been culled down by the Supreme Court. On a careful consideration and scrutiny of the law on the subject, the following principles are well established. That where the copy of the election petition served on the returned candidate contains only clerical or typographical mistakes which are of no consequence, the petition cannot be dismissed straight away under section 86 of the Act. So this is the principle, clerical mistakes. 2. A true copy means a copy which is wholly and substantially the same as the original, and where there are insignificant or minimal mistakes, the court may not take notice thereof. 3. Where the copy contains important omissions or discrepancies of a vital nature which are likely to cause prejudice to the defense of the written candidate, it cannot be said that there has been a substantial compliance with provisions of section 81(3). Prima facie 4. Prima facie, the statute uses the words true copy, and the concept of substantial compliance cannot be extended too far to include serious or vital mistakes which shed the character of a true copy, that the copy furnished to the returned candidate cannot be said to be a true copy within the meaning of section 81(3) of the Act. 5. As section 81(3) is meant to protect and safeguard the sacrosanct electoral process so as to not disturb the verdict of the voters, there is no room for giving a liberal or broad interpretation of provisions of the said section. So it has to have a strict, only those typographical, clerical mistakes here and there that can be condoned. But this is of a vital nature.
Yes.
So, my lords, that, and in that view, the Supreme Court went ahead, and in paragraph 17, in the view that we take, it is not necessary for us to wade through a detailed discussion of mistakes. A few mistakes pointed out by the judge himself clearly reveal that they were of a very vital and material nature, so as to mislead the returned candidate and prejudice him in his defense. Schedule 1 to the election petition contained the list of persons through whom the corrupt practices were alleged to have been committed. An analysis of these may be placed in 3 categories, so on and so forth. So they enumerate the mistakes, and thereafter, my lords, para 21, my lords, the principle of Murarka Radhe. Thus, on an overall consideration of the facts and circumstances of this case, we are unable to agree with the High Court that the mistakes in the copy were either verbal or typographical or clerical. The present case appears to be a much worse case than Murarka Radhe Sham case, where only slight difference in the title led this court to hold that the mistake was a vital mark. We are therefore of the opinion that the High Court committed a serious error in holding that there had been a substantial compliance of the provisions of 81(3). So Murarka Radhe, the principle, the leading judgment has been considered, and also those aspects are there. Now, my lords, furthermore, there is one more judgment of Sharifuddin, which is also 1981 SCC 403.
He was part of the earlier bench. Oh no, this is earlier to the other.
Yes. It is earlier to
This
the
is 1918.
1981 SCC.
Others authored by Mahimuni.
No, earlier one.
It is authored by Justice Venkataraman.
Yes.
Fazal.
Yes, Lord. So, Lords, in this judgment, your Lordship may take this, my Lords, considers the situation as far as the Jammu and Kashmir Representation of People's Act, which is paramateria with the Representation of People's Act. So, para 6, my Lords. It is admitted that neither of the two copies of the election petition which had been filed along with it had been signed by the appellant. Both the copies contained identical endorsements at the foot. Attested true copy, Pyare Lal Handu, the advocate. In our case also, all the annexures have been, the petition nowhere mentions it is a true copy. The annexures are certified to be the true copy by the advocate. So, my Lords, thereafter, para 9. The difference between a mandatory rule and a directory rule is that while the former must be strictly observed, in case of the latter, substantial compliance may be sufficient to achieve the object regarding which the rule is enacted. Certain broad propositions which can be deduced from several decisions of the court regarding the rules of construction that should be followed in determining whether a provision of law is directory or mandatory may be summarized thus. The fact that the statute uses the word shall while laying down a duty is not conclusive on the question whether it is mandatory or directory provision. In order to find out the true character of the legislation, the court has to ascertain the object which the provision of law in question has to subserve and its design and context in which it is enacted. If the object of a law is to be defeated by non-compliance with it, it has to be regarded as mandatory. But when a provision of law relates to the performance of any public duty and the invalidation of any act done in disregard of that provision causes serious prejudice to those for whose benefit it is enacted, and at the same time who have no control over the performance of the duty, such provision should be treated as a directory one. Where, however, a provision of law prescribes that a certain act has to be done in a particular manner by a person in order to acquire a right, and it is coupled with another provision which confers an immunity to another person when such act is not done in that manner, the former has to be regarded as a mandatory one. A procedural rule ordinarily should not be construed as mandatory if the defect in the act done in pursuance of it can be cured by permitting appropriate rectification to be carried out at a subsequent stage, unless by according such permission to rectify the error later on, another rule would be contravened. When a statute prescribes that a particular act is to be done in a particular manner and also lays down that failure to comply with the set requirements leads to a specific consequence, it would be difficult to hold that the requirement is not mandatory and specific consequence should not follow. This is, my lords, in context of section 81(3) and 86. Even after the judgment of Murarka Radhe, the Supreme Court reiterates that it's a mandatory provision, and if you do not comply with it, it would lead to dismissal of the election petition. One more paragraph, my lords, on para 19. An election to a legislative assembly can be called in question only by filing an election petition and not otherwise. The right to challenge the election by filing an election petition is a statutory right and not a common law right. A successful candidate is entitled to enjoy the privileges attached to the membership of the Legislative Assembly unless his right to do so is successfully challenged in the election petition filed within the prescribed period and in accordance with law. Section 89(3), this is 81(3) in Representation of People's Act, of the Act consists of two parts. The first part requires that every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and the second part requires that every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition. The first part of Section 89(3) of the Act has been held to be a mandatory requirement by this court in the case of Satya Narayan, as this court was of the view that the copies of the election petition should be filed along with it in order to prevent the delay in disposal of the election petitions. The question whether a provision of law is mandatory or not, as observed already, depends upon its language, the context in which it is enacted, and its object. Subsection 3 of Section 89 of the Act provides that a copy of the petition shall be attested by the petitioner under his own signature to be the true copy of the petition. The emphasis in the above provision appears to be on the words under his own signature. We do not find the same expression used in Section 91(c) of the Act, which provides that an election petition shall be signed by the petitioner and verified in the manner laid down in the Jammu and Kashmir CPC for verification of pleadings. Subsection 3 of Section 89 of the Act was inserted in the Jammu Kashmir Act of 1962. Section 94 of the Act, which requires the High Court to dismiss an election petition when the petitioner has not complied with the provisions of Section 89, was enacted in the place of Section 94 of the Jammu Kashmir Act of 1967 with the full knowledge of the requirements of Section 89(3) of the Act. The object of requiring the copy of an election petition to be attested by the petitioner under his own signature to be a true copy of the petition appears to be that the petitioner should take full responsibility of its contents, and that the respondent or the respondents should have in their possession a copy of the petition duly attested under the signature of the petitioner to be the true copy of the petition at the earliest possible opportunity, to prevent any unauthorized alteration or tampering of the contents of the original petition after it is filed in the court. We have no doubt that the records and documents in custody of the courts are taken due care of by the courts, and the courts would not by themselves give any scope of tampering with them. But still, experience shows that allegations are sometimes made that the records in the court have been tampered with, notwithstanding the care and caution taken by the courts. Such allegations may not always be without basis. It is probably to obviate any scope for such allegations being made, or to protect the interest of the respondent, the legislature thought of enacting subsection 3 of Section 89 of the Act, so that the respondent may rely on the copy served on him when he finds that the original document in the court contains allegations different from those in copy of his custody. A respondent would have the same degree of assurance if a copy served on him is one attested by any person other than the petitioner himself. The attestation by the advocate of the petitioner cannot be treated as equivalent of attestation by the petitioner under his own signature. If the requirement of the second part of Section 89(3), that the copy of the petition should contain the signature of the petitioner himself, is not one of substance, there was no need to enact it as the first part of subsection 3 of Section 89 of the Act would have been sufficient, for it provides that every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and the word copies mentioned therein can only mean true copies. The importance of the provision contained in Section 94 of the Act, which makes it obligatory on the part of the High Court to dismiss a petition when it is established that Section 89 of the Act had not been complied with, also cannot be overlooked. And thereafter, the petition was dismissed on this issue. So, that's it. I will just indicate the paragraph of the judgment which is mentioned herein, Satya Narayan, because the Supreme Court in this, at 411, page 411, Satyanarayan is mentioned. I'm just the internal page 411 of the yes. So the judgment of Satyanarayan has been referred. I'm just indicating the paragraph. I'll not. Yes.
Read the paragraph.
Yes. Sorry. Yes, Manoj. Yes, Manoj. This is para 2 and Manoj's 13. So Manoj, para 2 is the facts whereby copies were not supplied. At the time of the facts may be briefly stated. In the general election to the Haryana Legislative Assembly, the appellant and the 4 respondents were contesting candidates from the so-and-so assembly constituency, 2 candidates having already withdrawn from the contest. The counting of the votes took place on March 12, 1972, and on the following day, the counting disclosed that the first respondent obtained so-and-so votes as against so-and-so votes secured by the appellant. The first respondent was therefore declared elected on March 13, 1972. The appellant filed an election petition in the High Court challenging the election of the first respondent on several grounds of corrupt practice within the meaning of Section 123 of the Act. It is not necessary for the purpose of this case even to detail this. The election petition was presented by Mr. R.S. Mittal, advocate in charge, to the Deputy Registrar. The same on so-and-so date. It is admitted that the application was filed on April 18, 1972 without requisite spare copies and was therefore incomplete on the date of presentation. No schedules were also filed along with the petition, but that point is not pressed before us by the Respondents' Council. It is also admitted that the limitation for filing of the election petition was up to April 27, 1972. According to the appellant, the spare copies were filed with the Superintendent of Election Branch in the afternoon of April 24, 1972, well within the period of limitation. So that is, Milords, the genesis of this judgment.
19.
Yes, Milords. Para 13, Milords. Para 13.
13.
Keeping in view the forefront of the proper functioning of democracy, the principal object of the Act is purity of elections. When therefore an election petition of a written candidate is challenged under the Act, the expeditious trial of the election dispute is sought to be enforced by the legislature, making all safeguards against delay. Trial has to be necessarily expedited to rid the candidate as well as constituency interested in the result of the election of any taint or suspicion of corrupt practices which are again clearly enumerated in the Act. To take therefore another important object of the Act, expeditious disposal of the election petition by Section 86B, the trial of the election petition shall, so far as practicable, consistently with the interest of justice in respect of the trial, be continued from day to day until its conclusion, unless the High Court finds the adjournment of the trial beyond the following day to be necessary for reasons to be recorded. Against Section 86(7), every election petition shall be tried as expeditiously as possible, and endeavour shall be made to conclude the trial within 6 months from the date on which the election petition is presented to the High Court. Further, 87(1) introduces the CPC only subject to the provisions of the Act, main rules thereunder. 87(2) makes a deeming provision for application of the Evidence Act. Therefore, there is no scope of free play in the application of provisions of those two acts. The very object of the expeditious trial will be defeated if the presentation of the election petition could be treated casually and lightly, permitting all kinds of devices to delay the ultimate trial. The purpose of enclosing the copies of the election petition for all the respondents is to enable quick dispatch of notice with contents of the allegations for service on the respondent or respondents, so that there is no delay in the trial at this very initial stage when the election petition is presented. If there is any halt,
taking the context, the 60 and the time there was no photocopying and all, at least now a different, it should be a different take on it.
Malaj, the two aspects which, if I can understand what
limit the replies to
only that issue.
Yes.
But before that, my lords, there is this other issue. We'll come to that. Now, the first issue, my lords, if I can understand what my learned friend is saying,
Yes.
my lords, as your lordships have seen, I'll strictly try and restrict myself to the law. Now, as your lordships have seen, my lords, it is more of substance than of form. That is the law. The interpretation, my lords, whichever judgment has gone either way, including the Constitution bench judgments, is, my lords, 81(3) has to be substance over form.
See, one thing coming to this, your judgment, now it says that there's that one line there.
My lords are referring to, my lords, Murarka Radhe, my lords.
Your compilation.
My lords. Murarka Radhe, my lords.
That, has...
It means a copy so true that nobody can any possibility of misunderstanding it, my lords. That's exactly what I'm coming to. That's what I'm coming to, my lords. My lords. So if, my lords, I am misunderstood, if my lord, I have served a copy by which I have misunderstood the contents of that petition, in my application under section order 7 rule 11, I will say how I have been misled. That's fundamental. I can come and argue, my lords, the heaven and the hell, but the fact of the matter remains, if I am filing an application under order 7 rule 11 before this honorable court, as your lordships have seen the law is, I would have to demonstrate, my lords, how I have been misled or I have misconstrued or misunderstood, my lords, what is there? My lords. So my lords, the first thing is, so my lords, I will take your lordships to the application.
The same copy of those
My lords, I will take your lordships to the application under order 7 rule 11 because he would have to first demonstrate how is he prejudiced.
Okay.
If I am saying, my lords, I am prejudiced by a certain act, I have to disclose how am I prejudiced. My lords, may kindly have a look at the application in the first place. Now, besides paragraph 1 of this application, which is a purely wrong statement, I am not even getting into that at this stage.
Yes.
So, my lords, may kindly have a look, my lords. I'll quickly read paragraph 1 as well. It does not disclose under what provision of order 7 rule 11, my lords, my application is to be rejected. That's number 1. Number 2, my lords, paragraph 1, my lords, may kindly, I'll just very quickly read it. The instant application under order 7 rule 11 read with so-and-so of so-and-so, it is being filed by the respondent pursuant to the leave granted by this honorable court by its order dated 15/6/2023. I've pointed out, my lords, there has never been any leave, no leave sought, no leave granted. And then, my lords, I have the audacity of coming and arguing before this honorable court that there is no compliance of the Guwahati High Court rules. And, my lords, I will take your lordships how this affidavit is affirmed. Now, my lords, may kindly have a look at paragraph 4. How I have been misled. That it is submitted at the outset that the present election petition has approached this honorable court with unclean hands. Very well. The petitioner has filed a copy of the election petition served on the answering respondent bearing notarial stamp of so-and-so, whereas the copy of the election petition filed in the registry is notarial stamp of so-and-so. Very well. That similarly, the affirmation of annexures to the true copies of the respective originals have been done by the advocates of the petitioner served by the respondent who are the election petitioner, and therefore the said affirmation is without any legal sanctity and is clearly hit by section 81(3) of the RP Act. Very well, my lords. That there are several other points, differences between copy of the petition served to the answering respondent and the copy of the petition filed in the registry of this honorable court. Such a practice is not only violative of the rules of this honorable court but also fraudulent in nature. By serving a different copy and filing a different copy, the petitioner has attempted to play fraud on this honorable court. Well, it's whom am I playing fraud on? This honorable court, not on the petitioner.
No. Yes.
And has committed acts of perjury tantamount to misleading this honorable court. Very well.
One thing, first of all, we have to confine only as whether you file your
my lords,
election as per the requirement.
My lords, for that, my lords, I am coming. My lords, I am coming to that.
Yes.
If somebody is complaining, my lords, that yes, 81(3) has not been complied, Murarka Radhe and the other judgments categorically point out, my lords, that he has to show how he has been misled. That's why they say it is of substance and not of form. And I'll take your lordships to 2 other judgments on this very issue. Clerical, arithmetical, some other mistake, signature not there. My learned friend has gone on notary, my lords. I'll take your lordships to the issue of notary also. Notarization is not something that's contemplated under the Act. I cannot import something and put it on the Act. 83 does not talk, 81.3 does not talk about notarization.
No, does not talk about true copies. What are true copies?
My lords, that I'll take your lordships, what is a true copy?
Yes.
So, my lords, first issue is I'm trying to, so I would have to discharge a responsibility that is, my lords, as a corollary to 81.3 falls upon me to show how I've been misled. So, paragraph 4, my lords, is silent on it. My lords, may kindly have a look at paragraph 5. It is submitted that the differences in the copy filed before this honorable court and served on the answering respondents also cast serious doubtness on the genuineness of the affidavits and whether they have at all been executed and notarized in accordance with law. So that is a genuine grievance. He may say that whether it is a genuine affidavit, whether it's notarized in accordance with law. This is the issue, my lords. In respectful submission of the answering respondent, the violations on the part of the election petitioner warrant a detailed inquiry by this honorable court through an appropriate authority appointed in this behalf. There is not a whisper saying that, my lords, I have been misled into believing something.
Okay.
The two judgments that my learned friend placed now, my lords, I'll replace them. Because the Honorable Supreme Court says that.
Yes.
As a matter of fact, my lords, that judgment from Jammu and Kashmir, your lordships would have seen. Where there's an allegation of corrupt practice and I have not laid out the details, yes, that would be of substance, it would not be of form. So, 81.3 gets attracted, I would have to be thrown out. That's not the case here.
Yes.
So, my lords, in the first instance, the applicant before this honorable court has not made a single averment as to how he has been misled to believe that it is not a true copy. And what prejudice a so-called, my lords, not so true copy has caused to him. Because your lordships at this stage are throwing away, my lords, a very serious allegation of corrupt practice.
That is why,
my lords, your lordships have...
The purity of elections demands that, in the entire process of even swearing a single page or paragraph, has been done, in a manner so provided. That is why such a high standard of,
My lords, I absolutely bow down.
We are looking at in a democratic process. If a person has been returned as a candidate in won the elections now, to unseat him, the procedure has to be
My lords, with all due respect.
And with all due respect, all the legal fraternity, the way these petitions have been filed, I left wanting.
My lords, I bow down.
Crashing around.
My lords, I bow down.
Instead of going forward, to address the
true issue.
Exactly.
My lords.
And so we are bogged down by this.
So-called technicalities, my lords.
It pains us.
My lords, I bow down.
There might be glaring in some corrupt practices which should be addressed. But if technicalities overcome these,
my lords, which is why.
That is why.
My lords, which is why in the first, because my lords, initially when this matter was being argued, your lordships were also of the same view, and I was also of the same view, my lords, that it has to be in letter and spirit. When we dug up, my lords, and it's not one, it's the constitutional bench of this honorable Supreme Court, my lords, of this country, which has laid down that law. And that has continued till today, that's not been upset. So therefore they say, my lords, it's of substance and not of form. If there is substance in the allegation, my lords, yes, your lordships will throw me out. If it is of form, not necessary. Now, my lords, what my learned friend's objections is regarding notarization. My lords, I asked this question to myself, does section 81.3 talk about a notary?
Okay.
If it doesn't, my lords, can I import it from somewhere?
Is that question important? It's the question of you having imported yourself.
If, my lords, for the purposes of affirming an affidavit, if I have gone to a notary, the notarization is not correct. His remedy, my lords, I am not here in advisory jurisdiction to advise him. His remedy will lay elsewhere within the act. Okay. Not under section 81.3. Okay. My affidavit may be defective. Only for the sake of argument, my lords, I am conceding. May be defective. But whether it will attract 81.3, I cannot write something which is not there in the books of in the statute.
So see, we talk about two copies.
My lords, which is why I will take your lordships to one judgment. My lords, it's not that. It's my lords, I'll take your lordships to this very issue. My lords, I will take your lordships because
that copy.
This issue has also been settled.
Should be.
My lords, this issue has also been settled.
Now a copy should also be.
My lords, this issue is also settled. I'm fortunate that this is not the first time this has happened. This issue has been settled. And I'll take your lordships, my lords. May kindly have a look of my compilation. This is 2001 8 SEC 358. Pungzathang versus so-and-so, my lords, at page 41 of my compilation, if my lords kindly have a look at it.
Yes. Para 14.
Is a copy so true that can by any possibility that nobody can by any possibility misunderstand it. The test whether a copy is a true one or whether any variation from the original is calculated to mislead an ordinary person. Applying the test, we have to come to the conclusion that the defects complained with regard to so-and-so were not such as to mislead the appellant. Here, my lords, there is no averment saying that I am misled in the first place. My lords, if I may continue, para 12. And after, my lords, that's because they're continuing with Murarka Radhe, so I'll just skip that. My lords have already read. And after considering the similar views expressed by a later constitutional bench judgment in so-and-so's case, in Jacob's case, held that the object of serving a true copy on the election petition and the affidavit filed in support of the allegations of corrupt practice on the respondent in an election petition is to enable the respondent to understand the charge against him, so that he can effectively meet the same in written statement and prepare his defense. The requirement is thus of substance and not of form. Having come to the conclusion, the court in so-and-so's case, the expression copies in 81(3) of the Act, in our opinion, means a copy which is substantially so, and which does not contain any material or substantial variation of a vital nature as possibly mislead a reasonable man to understand and meet the charges, allegations made against him in the election petition. Indeed, a copy which differs in material particulars from the original cannot be treated as a true copy of the original within the meaning of 81(3) of the Act, and the vital defect cannot be permitted to be cured after the expiration of the period of limitation. From the above conclusion, the court in Jacob's case, two principles can be deduced. The expression copy in section 81(3) of the Act means a copy which is substantially the same as the original. Variation, if any, from the original should not be vital in nature and should not be such that it can possibly mislead a reasonable person in meeting the allegation. If the copy differs in material particulars from the original, the same cannot be cured after the period of limitation. Having laid down the law as stated above, the court of Jacob's case proceeded to apply the same test on the facts of the case and came to the conclusion that non-mention of the name of the notary, or in the absence of the stamp and seal of the notary, in otherwise true copy supplied to the appellant could not be construed as an omission or variation of a vital nature or defect. That settles the issue.
Can the different notary be taken?
My lords, as I submitted before your lordships, his remedy may be lies elsewhere, not under 81(3).
Because notary also is a...
All the my lords, all the judgments that have, my lords, all the judgments that have been placed before my lord.
One copy for this notary, number 1, and you serve a copy is one notary, number 2.
My lords, if I may say, that my lords, that may be my Achilles' heel. It may be my Achilles' heel, not to be adjudicated under 81(3).
Okay.
It's not a defect for the purposes of 81(3). Your lordships are aware, my lords, where I can be hit and at what stage I can be hit. Not at this stage. That's my only submission. Therefore, my lords, the judgments which my learned friend has placed, Satya Narayan as well as my lords Sarafuddin Abdul Ghani loan, which is what I was pointing out, my lords, my friend was my lords, kind enough to read the substance of these matters, my lords. These would be of no assistance for him.
Why?
My lords, if I may just point out, the first judgment that was placed, my lords, if I may, is the Maharashtra case.
Yes.
Para 10 was placed, my lords, where my learned friend went on, my lords, how notary and Mr. Sonavane's case. Para 10 had been placed before, my lords.
Yes.
I have said, my lords, for the purposes of 81(3), notary, non-notary is not necessary.
Yes.
That is of absolutely no substance insofar as an objection to 81(3) is concerned. So that would not be of any assistance. Now, the second judgment that they have placed, my lords.
Yes. That is the
Before that, my lords, I'm just placing this Sharifuddin Abdul Ghani loan. This is Venkataramaya's judgment, my lords. My lords, at the facts itself, my lords, at paragraph 2 would see that two preliminary issues were framed. Well, it's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. My lords, 11 lines from the bottom. It starts with on the basis of the above pleadings. On the basis of the above pleadings, the High Court raised two preliminary issues, one relating to the validity of the presentation of the election petition and other relating to the effect of the absence of attestation of the copies of the election petition by the appellant. That stage has not come. We are at the stage of rejection of plaint. On facts, my lords, this judgment is of no assistance to my learned friend. Then the last, my lords, Satyanarayan's case, paragraph 2 again. No, Satyanarayan is what has been placed by my learned friend now. This was, my lords, 1974, 4 SCC 237.
Oh, yes.
Para 2, the factual part. What was the defect?
Yes.
My lords, 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 lines from the bottom, my lords, paragraph 2.
Same was ordered.
The same was ordered. It was filed, before that it's filed on so-and-so date. The same was ordered to be put up for scrutiny on so-and-so. It is then admitted that the application was filed on so-and-so without the requisite spare copies and was therefore incomplete on the date of presentation. No schedules were also filed with the presentation, but that point is not placed. So there were admitted positions there. It is on that premise, my lords, that this judgment has come to be passed. Factually, that does not assist my learned friend. And therefore it can be distinguished. I think he has placed para 13. Yeah. Para 13. So it deals with presentation at 246 mils. The very object of expeditious trial will be defeated if the presentation of the election petition should be treated casually and lightly, permitting all kinds of devices and delay of the ultimate trial. The purpose of enclosing 2 copies of the election petition for all the respondents to enable quick dispatch of notice to all the contents of the allegations for service on the respondent, so that there is no delay in the trial at the very preliminary stage when the election is presented. If there is any halt or arrest to the progress of the case, the object of the act will be completed. This is on an absolutely different issue. Does not assist on the issue at hand. My lords, mandatory and directory in view of my lords, Murarka Radhe, there is no scope for mandatory directory. They say, my lords, 81.3 is mandatory, but they say what would constitute any petition to be rendered defective under 81.3. It is of substance and not of form. So as long as there is substantial compliance, my lords, merely because of these little fancy words of true copy and signatures and things like that, my lords, that as long as it is signed on every page by the petitioner,
will constitute.
And it has not deceived you or misled you of a nature that any reasonable person would be misled by that, it is substantial compliance and therefore would not attract 81.3.
Anything else?
Yes, just my learned friend wants to just point out this issue about the oath commissioner. Well, this is on the facts of the case. It deals with oath commissioner, but I will not really burden your lordships with that.
what judgments you have is...
We've already filed the compilation.
No, apart from nothing else.
Other than that, I don't think only my learned friend has filed. I've just tried to distinguish whatever is there. Because ultimately, Murarke Radhesham is the authority holding the field.
Very interesting point. Anything else to say, Mr. Pandey? No.
No, Milods. As far as
bullet points better, because otherwise it'll slip my mind.
Yeah, Milods. It won't end, Milods. It will keep on.
It'll just go on and on. The other aspect is, Milods, that the affidavit in support of his application itself is not in form, and on that ground only it has to be thrown out.
Yes, you filed 1 week.
My lords, if your lordship so please, I can just point out.
That is already there.
In the 711 application.
No, in the Order 7 Rule 11 application.
711 application.
My lords, kindly have a look at para 20. The affidavit is not even verified. It does not disclose
their own affidavit.
Yes, well, it's not verified. It's not a verified affidavit.
Sir, correct.
No, I just have to say.
I have a certified copy, it's a notarized copy.
Here's signed verification.
It is signed. The contents of the affidavit are not verified. The contents of the affidavit have to be verified for it to be a valid affidavit.
The other paragraph here.
Yes, my lords.
Yes.
And my lords, may kindly see how the contents of this petition are then verified. My lords, may kindly see, I have read and understood the contents of the accompanying application and the factual statements made hereof those in para 1 to 39, including 1 to 5. And the accompanying application are true to the best of my knowledge, belief and information, and legal submissions based on accompanying application based on the advice received by me. So there's nothing on record. Even though, my lords, he is referring to the records of this honorable court. All these elections...
Even in an affidavit for election, every line, even in one paragraph, there might be some matters of information, some matters of record also. So when you file this election petition also,
we have to say
in that part, the sentence from so to
part so and so is knowledge, part so and so is record.
That is to our understanding. That's what is done. Even in paragraph 1, that sentence is no record. The other sentences,
Yes, Manoj.
I am only reminded the one who throws the stone must be careful that my house is not of glass.
Now, all these objections ideally should have been taken by them in the reply, but that has not been taken.
I am on
the all these objections are now...
We have to assist my lords on this issue, Millets, whether there's substantial compliance or not. This nitty-gritty, I could have gone into that, Millets, but I've just pointed out that it is not coming within the scope of Murarka. That's all.
1 week for bullet point.
Item number 7.
Yes.
It was fixed for appearance of the private respondent, if I remember.
Where is the petitioner?
The petitioner counsel is also not available in that.
Who is the private respondent?
Private respondent number 8. I have the order. But
none appears for the petitioner, not for respondent by 8. Just after 1 week before the orders. Have it all been filed?
We have filed, my lord.
Yes.
Obliged.
Item number 8.
May I please, Your Lordship? Affidavit in opposition and rejoinder has already been filed, so the matter may be posted for the hearing, my Lordship.
Yes, Mr. Dev. The parties submit that the pleadings are complete, the is a matter for hearing and so on.
Published.
Item number 9.
May please, Lordship. Lordship, like to state that there's no contempt which lies in this matter, Lordship.
Why?
Lordship, this petition was filed on the 2nd of July, Lordship, and there was a stay order on the 1st of July, Lordship.
From where? Division bench?
Lordship, from Supreme Court,
Judgment
Lordship.
was of division bench.
Let's see. Yeah.
Yes.
Was the order of division bench?
Yes, Lordship.
It's a matter regarding that
directions were passed, Lordship. One was to substitute the punishment and consequent reinstatement.
Yes, in view of the order of the Honorable Supreme Court, whereby the order to be violated has been stayed, the contempt application is closed at this stage. Yes.
Obliged, Lordship.
Item number 10.
Here I have filed my rejoinder, Lordship.
The pleadings are complete.
10, 11 and 14 are connected, my lord.
Pleadings are complete or not?
My lord, here, my lord, MEC is also a party, but we have not filed an affidavit because the issue is with the FEDCO, my lord, regarding issues
But
of the
do you want to file an affidavit? Yes or no?
I have just received affidavit of FEDCO. I have to go to if any issues have to be addressed by MEC, my lord. I'm praying for time.
FEDCO is respondent number 4 and 5.
4 and 5, my lord.
Yes, MSR Colney.
Affidavit can be given by my friend who's representing FEDCO, my lord.
Sure, we'll do it.
Yes, MSR Colney, Learned Council, we have respondents number
1, 2, 3. Oh, 1, 2, 3.
1 and 2. 1, 2 and 3.
Lordship, 1 is government, Lordship. 1 is state.
For 2 and 3. Submits that though no affidavit has yet been filed by the respondents 2 and 3, some time is required to examine the affidavit filed by respondents 4 and 5 as to whether any additions are necessary from the part of respondent 2 and 3. Only up to 2 weeks. Yes. You supply copies?
10, 11 and 14.
Same.
Connected.
Same issue.
Electric.
Item number 12. 12.
Please, Your Lordship. Lordship, affidavits were forthcoming on the respondent authorities. However, no affidavits have been filed till date.
Now he is reinstated or not?
No, Your Lordship. Despite representations being made.
Which department?
ICR department, Lordship.
He's not been reinstated?
No, Your Lordship.
File contempt.
Yes, sir.
Lord, we have no role, my lord.
Lordship, I'm praying for another chance, Lordship, 1 week's time.
For instructions? Yes, we'll give you some time. Yes, MSS Berchiang by Dr. Musica. Please be allowed 1 week for a time to obtain instructions or to file affidavits. Make sure it'll be difficult because there's a big break in the service.
Yes, Your Lordship. Interim order will continue, Lordship.
And the scheme is still?
It's subsisting, Your Lordship.
Still? It's going to end soon?
It's going to end, yes, Lordship, in 26.
13.
That becomes a different issue altogether.
Yes.
13.
Lordship, the petitioner is supposed to have filed the rejoinder. We have not received a copy though.
You have already
filed, yes, Your Lordship. We have filed the rejoinder.
We have received yesterday evening.
You are for whom, Mr. Sangam? For?
I am for MBOS.
MBOS.
And we are for 1 to 7, Your
You
Lordship.
kindly share copies submitted by MS Ibla. The rejoinder has since been filed. Stop MST Yang EB for respondents
1 to 7, Your Lordship.
Submits that copies have been received. What about 8 to 10 received?
Or 12?
Yes. Receive or not? Yes, list a matter for hearing. Meanwhile, please supply copy to all the respondents. Yes. Just worry on so and so. Meanwhile, copies will be supplied to all. Rejoinder copies supplied to all the other respondents.
15. 15.
Yes.
May please, Lordship, by last order, Lordship, we had for order we have filed a affidavit.
Yes, Mr. Karim. Ready the matter?
Lordship, I pray that the matter will come at the bottom of the board, Lordship.
Bottom of the board? Where are we now? Near the bottom?
We might have it on some other day, Lordship.
Tomorrow? Today is Wednesday?
Today is Wednesday, Lordship.
Friday also we can't have it. We have Monday.
Lordship.
Yes, after the reply has been filed, stop this matter on Monday for further orders. To the miss case, the WPC 149 in so-and-so, introduction of 98, affidavit replies will file to the business application list on Monday for further orders. Yes.
Much obliged.
16.
Yes.
We filed an application for interim orders, my lord, for stay of the operation of the impugned orders. Lord, I humbly pray that the orders be stayed, my lord, during the pendency of the case, my lord.
To that, your lordship, we have a little bit of objections to that, lordship. We have to bring certain papers on record. So if your lordship may grant us some time to go through this.
You only got 2 weeks time last time.
Lordship, the miss case was filed just yesterday. We received a copy. We received a copy of it yesterday, lordship, in the evening.
We'll have it next week then.
My lord, prima facie, if my lord will allow me 5 minutes, my lord, prima facie, I'll be able to show you the direct documents which affect the petitioner.
No, the thing is that Mr. Whether that there is another authority you can approach, correct?
Yes, lordship. This is purely a civil dispute in nature, lordship.
I object to that, my lord, that the submission is actually incorrect. The issue that arises out of the case of the petitioner is that the respondents are attempting to enforce an order after a passage of 8 years, my lord. And they conducted an inquiry and even proceedings which the petitioner was not party to.
Are you seeking enforcement of some agreement?
My lord, I'm seeking enforcement of the petitioner's rights, my lord. They have violated the petitioner's right under Article 14, 19 and 21, my lord. And if your lordship would allow me...
They are basically aggrieved by an agreement which was not satisfied, lordship. It is not an enforcement of rights, your lordship. And moreover, your lordship, this...
No, see,
there's a question of...
Mr. in all fairness, you file a short objection to the miss case. Whatever. Mr. LCM prays you allowed 1 week's time.
1 week,
to file the objections and to bring other materials on the record. Lists after 1 week positively for consideration interim prayers.
My lord, if the case can be listed for admission hearing, my lord, since from your lordship it has fallen, the 2 questions have come out, and that is whether the case itself is a civil dispute and whether it's maintainable.
Okay, for admission hearing
I'll satisfy, my lord.
Yes, your lordship.
You file your objection. But if the enforcement agreement, then
no, my lord,
you can't apply. You can't file a writ for specific.
No, exactly, my lord. I am aware of that, my lord. I will satisfy your lordship to the fact that it is not a civil dispute. We have the option to approach the civil court for civil remedy. However, there is a constitutional violation of the petitioner's rights.
There are other things involved here. Number one, if it's civil nature, the disputed facts, correct? Now, sitting jurisdiction, whether we can ascertain whether what you have alleged has really happened. Number one. Number two, also whether you're seeing enforcement of agreement entered between you and the respondent.
There's constitutional rights which have arisen out of this.
And number three, where it affects, you can bring theory A is different. But the thing is that whether there's been anyway. Will not. Why should we? You argue on that day? Yes. So you understand what the parameters? Yes.
17.
Highly obliged.
My lord, 17 to 20 is analogous matter, my lord.
You restore licenses.
My lord, this is regarding cancellation of the PDS.
No, but cancelled already. My lord has passed order whereby no third-party right should be created, my lord.
Yes.
After that,
what has happened now?
No one is appointed.
Who's distributing
my lord, there is an interim committee been constituted, vigilant committee.
Who's distributing the food grains now?
There is a committee, and in the each and every place, special.
Who's special committee? Who constitutes special committee?
The Gaunbura, along with the other members of the village.
There, the food grains are being given to them.
The food grains are distributed by that committee, my lord. Under the under the order of 2022, my lord. Meghalaya food grains.
When will you file an affidavit?
My lord, the lead matter, my lord, this issue is pertaining to Dadingri subdivision.
See, one thing
that we are filing
the allegations were made 22 or 21 or something, and complaint was made 2 years ago, and actions taken now. If complaints were of that time, action is taken immediately.
My lord, may kindly have our affidavit, my lord. The lead matter is coming on 31st. On 31st July, my lord.
Where's the lead matter? It's here today.
No, my lord, it's not listed today, my lord. That is WPC 264, my lord. So we will be filing affidavit, my lord.
You're then lead matter also.
Mr. Sheikh is there, my lord.
Where's Mr. Sheikh?
Mr. Sheikh is there.
He with the other court maybe, because that matter was...
As per the, my lord, CIS is coming on 31st.
Six fair price shop holder has approached this honorable court, my lord.
No, we understand that. The thing is that now it has to come to a quick closure, whether your license should remain cancelled.
My lord is correct.
Or whether, whether...
My lord, the only issue remain here in this writ petition, my lord, whether they've complied the violation of section 13.
No, we have to go by control orders, yes, whether they complied or not. So the only thing is that that's why file the affidavits here also if necessary. If the lead matter will suffice because it's all on complaints, correct?
My lord, this has come for the second time apparently, my lord. So the other matter will have.
What's the lead matter?
The lead matter is WPC 264, 31st July, my lord.
Yes, as submitted by MSR Colney that the lead matter in these connected cases, namely being WPC number
264 2025.
264 is listed on 31st July.
My lord.
Lists all these matters together for consideration. It's also expected next date what required affidavits should be on board.
My lord.
Yes.
My lord, interim order may continue, my lord. The
interim order, if any, shall continue till next date.
My highly obliged.
Supplementary 1, item number 1.
There is a limited issue here. What has happened is, Millets, that under section 56 Millets of the Electricity Act, there has to be a 15 days notice given to us, Millets, for informing us. I'll just take Millets. We've reproduced section 56 Millets in the petition. It's there.
Where's MS Colney? Have you served notice?
Yes.
Yes. Kindly call them. They're here 1 second ago.
Para 8, if my lords can help.
Yes.
Well, it's section 56, disconnection of supply and default of payment, where any person neglects to pay any charge for electricity or any other sum, then for charge for electricity due from him to a licensee or the generating company in respect of supply.
Yes, MS Colney was here. Yes. Have you received notice?
No, my lord, I have not been served any.
Why you disconnected abruptly the entire...
Mr. Pandey is
here. Here, my lords, the notice was served upon them.
When?
Because
that is in fact part of the writ petition.
That's what we are saying. That's not a notice under section
6
56.
June 2020.
I'll take a lordship's notice. Page 20, if my lords have a look.
And this notice, in fact, my lords, was stayed.
I'm sorry.
And then thereafter.
Page 15 onwards, my lords, can I have it? Whether this is a notice under section 56, my lords, is the issue that would have to be determined
16
by
16 or 15?
15, my lords. 15, 16, it's a series of notices. It's the same notice. Notice of demand, outstanding dues, my lords, with reference to the subject cited above, in pursuance of the order dated so and so passed.
What is the form of a notice under section 56?
It has to very categorically say, my lords, this is the amount due. You have not paid it. And, my lords, if it is not paid, you were given time to pay it, you have not paid it.
Does not constitute a notice under section 56. Just 15.
In my humble submission, no. I'll point out why. If my lords may kindly see, paragraph 2 would be relevant. If this matter is not resolved by the time specified above, the corporation reserves the right to disconnect the power supply and commence legal proceedings to recover the debt without further notice to you. And this letter may be...
So your submission is that if there is proceedings prior to have no relevance, if there's a fresh disconnection, there will be fresh notice.
There has to be a notice, my lord, saying that this is the amount due, because current bills are all up to date, my lords. As a matter of fact,
yes, Mr. Pandey.
Two of them, my lords, the dates are on various dates.
Because this notice was stayed by your lordship in the proceedings in the review petition number 3, my lords. And yes, my lords.
In the initial stage, my lords, even when you had received this notice, because this was a demand, so my lords would recollect where we were saying that there is that differential tariff and para 35 had to be clarified, which my lords refused in the judgment. It is in that context, not on 56. 56 is specific, my lords. As a matter of fact, it says very specifically that there has to be a
15 days notice.
15 day notice specifying that this may be treated as a notice under section 56 of the Act.
This is in fact, my lords, a 15-day notice. There is nothing.
Substance of form.
So, I think Lords Murarka Radhe will apply to this case. So
now my friend will adapt my arguments there.
So, Lords, in this case, because now the situation is that the corporation cannot proceed. As soon as we take one step, my lords, we are taken 10 steps backward.
Would be making a demand, my lords.
An appeal is pending. Today, even an appeal has been filed challenging your lordship's review order, where this particular notice was stayed, my lords. They have their remedies before my lords the forum where they are contesting multiple forums. They are contesting the same thing.
I will just show my lords what we have got yesterday at page 23. After disconnection, what we've got. My lords, may kindly have a look at page 23.
Yes.
This is the typed copy, my lords. Tariff difference amount. This is dated 22nd July, my lords, but kindly see. With reference to the subject cited by persons of order dated so-and-so, Honorable High Court of Meghalaya, so-and-so, review petition number so-and-so, is due from your company and the tariff difference area payable in terms of the tariff order dated so-and-so passed by MSRC, which is yet to be cleared till date. The said amount is now outstanding for more than 6 months. Hence, a huge outstanding is accumulated, which in turn has led to severe financial hardship upon the corporation. Therefore, the corporation is compelled to act upon the disconnection notice under reference above and to effect disconnection of electricity supply to your premises. The power shall be restored only after necessary action is initiated from your end for clearing the amount of so-and-so. Pending payment, you will continue to be billed as per the provisions provided under the MSA.
Constitute the notice under 56.
That's what I'm saying, Milad.
So,
it does not say that had it been 56, Milad, they did not require to give us this.
The notices, my lords, kindly sees from page 15 onwards.
This, my lords, refers to the notices of 15 from page 15 onwards. This is not a notice under 56.
Onwards. 6th June 2025 notice of demand of outstanding dues. With reference to the subject cited above and pursuance of the order dated so and so.
Why don't you put this before the appeals where the matter is pending?
Yes, my lord. In fact, it is pending today.
No.
Pending today is listed
we are
today.
pressing a separate remedy of appeal. Like I said, my lords, I am not on that issue. That issue is a different issue. Here, my lords, the law requires that if you are to disconnect, you have to give a notice under section 56. Because there is, my lords, a corollary to that. Under 56(2), there is again another provision which says that it has to be continuously showed as a demand. If that is not showed within two years, it goes. That's why 56 and 56(1), 56(2) would be relevant. So I say if there's a notice under 56(2), my lords, I go. 56, I go. My lords have section 56. Where any person neglects to pay charge of so-and-so, any sum other than charge for electricity for the licensee of generating company so-and-so, willing to electricity to him, the licensee or the generating company may, after giving not less than 15 days clear notice in writing to such person and without prejudice to his rights to recover such charge or other sum by suit, cut off the electricity supply and for the purpose cut, disconnect electricity supply line and other works being the property of such licensee generator through which electricity may have been supplied, transmitted, distributed, so-and-so, together with
any other provision that deals with such situations whereby it's a continuing kind of offence?
No, my lords.
56(2)
yes,
would be relevant, my lords. May I kindly have a look at notwithstanding anything contained in any other law for the time being enforced, no sum due from a consumer under the section shall be recoverable after a period of 2 years from the date when such sum becomes first due, unless such sum has been shown continuously as recoverable as the areas of charges.
It's already been disconnected now.
Well, it was disconnected yesterday.
It has to be. It has to be.
It can't be, Millet. That's what we are saying.
It has to be. Today the situation is, if you are not able to succeed in getting this notice set aside, still this notice will be ineffective. This notice will be ineffective because you have to issue a fresh notice. Have you paid the amounts in terms of this notice? The answer to that question is no. As soon as your petition is dismissed, you have to go to the corporation, as certain members of the BIA have done yesterday. You have to go to the corporation.
It's been restored.
Yeah, for the people, there is a settlement.
No,
situation
not
is
the petitioners.
But you're part of the BIA.
Not the petitioners, Millet. Not the petitioners.
I have details, Millet. Those.
If I can have those details, nobody's gone.
I am on instructions, oral instructions. There are people who have approached yesterday.
Tomorrow is.
Yes,
my lords, if those details are shared with me, I can place it before my lords. Yes, I'm very specific, my lords, and your lordships can take my statement to the bar. Nobody's gone.
Senior counsel with so-and-so, stop issue notice, Mr. S. Pandey, present accept notice. We have all respondents?
All response. Yes,
all respondents, no further notice. A list tomorrow, in supplementary list for instructions.
Yes,
respondents.
Yes.
Hearing, supplementary list item number 3.
Obliged.
I'm praying for Passover for now.
Why?
Division bench will sit after some.
After 1 week.
Lordship, this
Next week, yes.
second half, Lordship, I'm praying.
Second half is a bit difficult there. I've got 2 meetings back to back.
Lordship, then I'm praying for Monday, Lordship. Monday, Lordship.
Monday, no. The Tuesday, no. Tuesday, no. Tuesday. It'll come in the main day soon.
25. Item 25.
Why do you want to do it now?
There's some matter before the decision bench to be there, Lordship.
Yes. Where's the petitioner?
25.
Mr. Rinja appearing for the petitioner?
Lord, actually, he is having a matter before division bench, my lord.
Your division bench, whom Mr. Sinkon?
Lordship.
Ms. Amir Kumar is appearing which matter?
Yes, Your Lordship.
Not possible for after tomorrow.
Next week,
Matters are being rolled over unnecessarily. Yes, next week, yes. Partner matters are being adjourned also, what can you say?
26.
26, 26 and 28 connected.
It was, partner matters were never adjourned. Yes. Next.
31.
Hello, Bletcher.
31.
Lordship, even 31 is an ACR matter, Lordship. After 2 weeks.
ACR matter?
This is an ACR matter, Lordship. After 2 weeks.
Why? Mr. Chanda?
No, Lordship. Lordship, there's another matter pending in the division bench. I'm just waiting for an outcome.
Okay, 2 weeks. So wait outcome of a an appeal pending for division bench.
Okay.
32.
Yes. Where's Mr. Chanda?
I believe not. If you want to, I just had a talk with Mr. Paul Millots. He is requesting. He told me that if the matter can be taken up after 2 weeks. If they want to proceed, I am ready, Millots. This matter has become infructuous, Millots, to a large extent because the contract has already been awarded and concluded.
You go for civil remedies. We'll close it, Mr. Thapa. Because last time you wanted to take instructions whether the people interested or not in pursuing this matter. As submitted by Mr. Pandey, that the matter has become infructuous in view of the fact that the stated projects also been executed.
Can you have this matter tomorrow or day after?
Executed. Mr. Skiriam praised without opinion instructions. List went.
Tomorrow or day after?
On?
As your lordship convenience.
Tomorrow. After 1 week, you get the instructions. If that's the case, then you have to file a suit, whatever. Yes.
Yes.